Welcome back. I hope everybody's had a chance to have a bit of a coffee or and a break. And we're going to start the compliance presentation now. It's funny, when I first started being a presenter, I was always told that you should start with a joke or a cartoon or a piece of poetry. So I have starting with one of my favourite odes, and it is the Ode to Compliance. The compliance profession is seen through the eyes of the disenchanted, talking about financial planning dealer groups and their compliance. In addition, it creates a heavy internal attraction for the functionally field incompetent compliance industry, whose entire purpose is to bludgeon advisors into submission, limit innovation, and ensure insipid, mediocre, disclaimer-rife, legalistic, gobbledygook advice to protect the licensee from ASIC. Along the way, the compliance profession attracts the insecure, sadistic, blindly ignorant, functionally incompetent, abusively bullying sergeant majors who can self-gratifyingly lord over advisors for minuscule documentary mistakes or omissions, constantly threaten them with termination and or breach reporting suspensions, and create an ego-driven corporate power centres. And I've seen this on a number of occasions from people who I would knowledgeably not hesitate to call sociopaths. Now, an interesting ode, and you might think that given the fact that somebody in ASIC decided that it was going to be a good idea to put through 4 different changes to legislation over a 2-day period at the start of this month, that the whole business of financial planning is all about compliance. Well, the last time I actually used this was back in 2014, and it was after the implementation of FOFA and coming up to best interest duties. But it was actually written in 2005. And you might have guessed that because they're talking about ASIC and not just ASIC and FOS and AFCA in the protecting of the licensee. And it just goes to show that over the years, not a lot has changed. We've lived through, and I've had advisors and commentators on the industry tell us that the whole industry is going to collapse at numerous intervals. There was the FSR legislation that came in 2004, and that was going to be the end of the industry. All of a sudden, we were going to have statements of advice rather than the previous consumer advice records, all sorts of changes. And then we didn't get that right. And it did lead to the 100-page statements of advice. And we've been trying to correct that ever since. And just like we got over 2004, we got over 2013, 2014, we will get over 2022. And today, I just want to recap a little bit and provide some feedback to the recent DDO legislation and IDR, and I want to give some meat to the complaints and advice, and then there's some time for questions as well. So DDO implementation, and I want to start by saying that just because DDO came in on the 5th of October, personal advice has not changed. What was good advice in September is still good advice in October, and what was bad advice in September and inappropriate advice in September will still be inappropriate advice under DDO. The existing investments that were held by clients prior to the 5th of October are not captured. Okay, you don't have to go back and worry about whether or not the advice to go into, or the advice or dealing with an investment prior to the 5th of October is in terms of the TMD. That's just not into it. And SMSF funds, even though they have a PDS, do not require a TMD. It is only underlying platforms and investments. And the TMDs don't have to be provided or signed off by clients. It is a tool, and it is the responsibility of a lot of the responsibility has been placed onto distributors, not issuers. But that was always the case. I mean, the issuers were always the ones who were deemed by ASIC and by AFCA to be the gatekeepers to the industry, and that hasn't changed. What it does mean, though, is that the issuers have been put on notice about ensuring that their products are fit for the markets that they are being invested into. And if you think back to schemes such as schemes that were massively oversold to the wrong people, like the managed investment schemes and trees, and also in some cases the massive overselling of some unlisted property trusts and the like, the requirement now is going to be sheeted back home to the issuer, as well as just being worn by the distributor. And the good news is that for personal advice, which is the field that most of us actually operate in, it's not a major change, and we don't have to really stress about it. What we do have to consider is the significant dealings. And just like most things that come out of Puzzle Palace, which is ASIC, the term significant dealing, which is thrown around with gay abandon in the actual regulations, is not defined in those same regulations. And so the test for a significant dealing is about the likely harm. And it is certainly likely that TMDs are going to be refined over the next 12 months. And this will often be as a result of the significant dealing reports. So, we're already starting to see that there are products out there that have got target market determinations that are putting them outside of the areas where advice is wanting to be given in them. And one of those is an insurance product that's designed for the professional investors, and it makes no allowance for execution only or for general advice. It requires, as part of its target market determination, the need for personal advice. The likelihood is that the issuers will realise over the next 12 months, A, that they're missing out on a lot of business, which they don't want to do, but B, that they're having to deal with significant dealing reports, and in something like that, it would be an escalation to ASIC because it is completely outside of the target market determination. And advisors are going to need to complete a significant dealing report to escalate to us as the AFSL within 10 days of the advice or dealing. So, what that means is that if a client comes to you and wants to undertake execution only, and that product doesn't, they don't meet that target market determination, it's not that you can't do it or that, they're banned from doing it. You've got to still make that assessment as to whether it's ultimately going to be in their best interest. But what it does mean is that you've got to complete the significant dealing report within 10 days of the advice dealing. And I want to express again that a significant report, dealing report, is not indicating that a breach has occurred. Okay, there will be a number of significant dealings that aren't as a result of breaches or anything else like that. It is simply outside, and the significant dealings are applicable to retail advice and dealings. It's excluding the execution only and general advice where for the personal advice consideration. So, giving personal advice means that you only need to provide a significant dealing. If you are doing execution only or general advice, you will still need to meet the reasonable test for it. Sorry, the mouse doesn't seem to want to go terribly quickly on it. So the examples of a significant dealing needing escalation. So I've just picked here the Magellan Global Fund target market determination because, like most fund, it adopts the traffic light indicator, and under the consumer's investment objective, it's green for capital growth and income distribution. Capital preservation is orange, which means that, that's the warning, if you like. It's similar to most traffic lights. It doesn't mean speed up and go through. It means, look at it, prepare to stop. And capital guaranteed, because it's not, is red. The consumer investment timeline, and they use a short being under 2 years, a medium being greater than 2 years, and long being 8 years. We would normally look at long as being, 7 years, 6 to 7 years being a long term, but they've gone for 8. And obviously short term, red, that 2 to 8 years being orange, and long being green. And the consumer risk, so that's the ability to bear loss and the risk return profile. A low risk is red, a medium risk is orange, and the high and very high are green. And, when we're talking about that, we're talking about applying that to our risk indicators and the risk profile. So obviously this is not a fund that would be suitable for a conservative. It would have a cautionary look for someone who is potentially mod con and balanced, and is obviously suitable for someone who is growth or assertive. And what they are also saying is that the consumer's intended product use is green right across the board. So that's standalone as a core component or satellite. And it's also green for the consumer's need to withdraw money in every situation from daily to annually. So having a look at that, what does it actually mean for giving advice? So in this case, any one of the 3 reds would be a significant dealing that requires escalation as the potential risk of harm is significant. 2 or more of the orange is likely to be a significant dealing requiring escalation. Magellan, in their target market determination, say that 3 orange is, in their mind, a significant dealing that requires escalation and would likely require them to escalate it to ASIC once they've received it. So could you use this fund as part of a diversified allocation of funds for, say, a medium risk client? So that's ModCon or balanced. And the answer is yes. So if the investment time frame was long and they were seeking capital growth or income distribution, even though it is an orange warning for the medium risk, that's not a problem. It doesn't need to have a significant dealing report, and it can just go ahead and form part of that portfolio. And you will see that there is no need to put into that decision consideration of their need for money or whether or not it is a standalone core or satellite fund, because this fund is assessed as suitable by the issuer for all of those. Now, if the client was balanced and had a medium investment time frame, but it's being used as a satellite fund as part of a diversified portfolio, could it be used for a client seeing capital growth or income distribution? Yes, but it would need a significant dealing report. Now, that significant dealing report, because Magellan are saying that 3 oranges require escalation to ASIC, it would be unlikely to be escalated to ASIC by the issuer, but they still have that, that's their decision to be made. And at the AFSL level, we would be making that decision to escalate to the issuer the significant dealing report. If the client was seeking capital guaranteed, then it's not within the target market determination. And if it was done as execution only, it is still likely that upon escalation, the issuer would need to further escalate that to ASIC, even if the rest of the areas in the target market determination were all green. So I hope people, are understanding that. And for a fund like this, it is not a matter of whether or not you are putting 10% of the fund, 20% into the fund, because this is about personal advice. And under personal advice, you would normally be making the decision as to how much on best interest to be putting into, say, a diversified portfolio. And remember that, the significant dealing is the only part of the decision that needs to be made where you are giving personal advice. The rest of it comes under the normal personal advice and best interest. So CMD, significant dealing and best interest. At all times, regardless of the target market determination, personal advice has to adhere to best interest duty first and foremost. And that's why we have an exemption from the DDO requirements other than the SD reports. Now, the catch-22 or the what I call the old fat guts Palmer gift that he keeps on giving us, because when we look to put in place the original best interest, we were going to get rid of the clause that deals with any other reasonable consideration, because it's far too broad. But unfortunately, that had to be kept in because to get the legislation through. And because of that, you would need to include a consideration of the TMD in providing the advice. And an example of that would be products such as the PPS insurance product that I said before, which requires personal advice, and therefore execution only or general advice are outside the TMD and would also fail to meet best interest. This is a potential change from last month, or not a potential change. This is actually a change from last month. But again, it's a very, very small part of the advice that we would be giving. And in the Magellan scenario, the funds into a product where there is an orange target market determination for capital preservation. And that really hasn't changed from last month. Now, I saw up there that there was a question coming through about target market determinations. Do they all have the traffic light system? No. It has been, and most of the TMDs that operate under the Financial Standards Council template are set up on the TMD, are set up on the traffic light system. However, what is in place of the traffic light system for the ones that don't have that system, you will find that the same different scenario areas are included in the TMD, and they will talk about whether or not the advice is or the product is suitable for that particular client, or whether there is caution or whether it is unsuitable. And that will often apply for insurance dealings. And if you look on our own separately managed accounts, so the Interprac growth and the Interprac income portfolios, they have a target market determination which doesn't use the traffic light system because it's been done by Hub24 as the SMA provider, and it simply breaks down the areas and says what is suitable and what is not suitable for an investment in that.